Hello, my dear students. In this law of banking, today I will take up the lesson 1. In this lesson, I introduce you to the law of banking in general, and I will deal with the definition and meaning of banking. Further, I will explain the evolution and development of law of banking in India. Finally, in this lesson, I will explain the form of banking institutions, that is, how to carry the banking business in India, like the company form or a cooperative society and so on. Before we study the law of banking as a regulator of banking business, it is interesting to know how this banking concept was developed. Legal history shows that in commercial world, the business community wanted to design a system to borrow money for business purpose, and further also wanted to deposit money and valuables for safe custody with trustworthy people, and thus the system of banking was evolved. The word bank was derived from the French word banquus and also banca, which mean bench. Bench means transactions of business in the marketplace on a bench. This was taken as a practice in Italy by Jewish money changers. There is another school of thought that the word bank was derived from the German word Back, which means a joint stock fund. Banking operations revolved around the activities of depositing money and valuables and borrowing loans on interest. Basically, these are the functions of banking. Different definitions were given by the jurists, courts, and statutes, but commonly they are based on the above functions of depositing money and borrowing of loans on interest. In the recent times, the definition of banking was explained into multifarious activities of banking institutions under various legislations related to the banking business operations. The development of banking concept goes back to the Babylonians. The Babylonians stated to have developed the banking system in 2000 BC. The practice was that the people used to deposit their money and various valuables with the temples. The Romans and Mohammedans resorted to lending but prohibited charging of interest on money borrowing, treating it as a sin. In India, the banking system was developed in the form of depositing of money and also pledge of valuables in the Smriti period and subsequently in the Vedic period. The Manusmriti contains an important chapter on deposits, pledges, and charging interest on loans. The Kautilya's Arthashastra also contains details on interest on loans. Thus, the banking system was evolved as a necessary commercial practice, and it has been given legislative sanction in various countries. In India, the British government first brought the legislations to regulate the banking business. To a very greater extent, the Indian banking law is based on English law. In the last 2 decades, several legislative changes were brought in the Indian banking system in tune with the changing economic, social, and political scenario in India. We will now learn about the definition and meaning of banking. Banking basically means depositing of money, valuables, obviously for safe custody, with the banker, and withdrawal of money deposits and taking loans. In the modern business world, pledging of valuables, securities, etc. for raising loans has become an integral part of banking activities. The proper method of finding out the meaning and definition of a legal term is that first we should look at the law that deals with the particular subject so that the term may be defined in that particular law, which is also called the statute. Secondly, we have to search for the meaning of the term in the decisions of the higher courts like High Court and the Supreme Court. We can also look at the juristic opinions and finally the dictionary meaning. We may also refer to the General Clauses Act 1897. The term banking was defined under several statutes by several jurists and courts. Some of them are narrated in this particular lesson. We will take up first the Banking Regulation Act 1949. Under Section 5B of the Banking Regulation Act 1949, banking means the accepting for the purpose of lending or investment of deposits of money from the public, repayable on demand or otherwise, and withdrawable by check, draft, order, or otherwise. This definition implies several characteristics of banking. Let us look at one of each of these characteristics. 1. Acceptance of deposits. The purpose must be acceptance of deposits of money. Next, acceptance of deposits for the purpose of lending or investing the same. If there is no intention to lend or invest the deposits so collected, it's not banking business. As it is evident from the explanation given under Section 5C that any company which is engaged in the manufacture of goods or carries on any trade and which accepts deposits of money from the public merely for the purpose of financing its business, as such manufacturer or trader shall not be deemed to transact the business of banking. Now, the next characteristic is deposit of money. It means the deposit of money only, that is legal tender currency by way of cash or check, demand draft, etc. But other than money, nothing else. Then the other characteristic follows, the deposit of money from public, which means that the deposits could be made by any member of public and implies that any person. A person includes the individual, a firm, a company, a cooperative society, a Hindu undivided family, any juristic person, a body corporate. Next characteristic is repayment. The money so received must be returned either on demand or as per the terms of the deposits. Then withdrawal. The modus of withdrawal is either by way of a check, draft, or as per the terms accepted by the parties at the time of making the deposits, which implies that the withdrawal should be as per the stipulated procedure. Then let us go through some of the definitions of jurists and the courts also. So let us take up the definition given by Dr. Herbert L. Hart. In his Law of Banking, he defined banking by describing a banker as one who in the ordinary course of business honors checks drawn upon him by persons from and for whom he receives money on current accounts. This particular definition of Hart was based on the decision of the English court in Foley versus Hill. Let us now look at another definition given by a legal luminary, Sir John Pegott, an authority of banking law. He observed while commenting on the Birkbeck Building Society case that no person or body corporate or otherwise can be a banker who does not take deposit accounts, take current accounts, issue and pay checks, collect checks crossed and uncrossed for his customers. These functions are today the essential functions of the banker. Now let us look at the Halsbury's Laws of England. In his Halsbury's Laws of England, Halsbury defined the banking, identifying with a banker as an individual, partnership, or corporation whose sole predominating business is banking, that is, the receipt of money on current or deposit account, and the payment of checks drawn by, and the collection of checks paid in by a customer. Now let us look at a judgment of Supreme Court of India. It was given in Vimal Chandra Grover versus Bank of India. The Supreme Court of India, quoting the concise Oxford Dictionary, stated banking as business transactions of a bank. Further quoting Black's Law Dictionary, the Supreme Court said that banking is the business of banking as defined by law and custom, consists in the issue of notes payable on demand intended to circulate as money, when the banks are banks of issue, in receiving deposits payable on demand, in discounting commercial paper, making loans of money on collateral security, buying and selling of bills of exchange, negotiating loans, and dealing in negotiable securities issued by the government, state, and national and municipal and other corporations. The banks in India are governed by the Banking Regulation Act 1949. Under its Clause B of Section 5, banking means the accepting for the purpose of lending or investment of deposits of money from the public, repayable on demand or otherwise, and withdrawable by check, draft, order, or otherwise. This definition rather covers the multifarious functions of modern banking in India. Thus, the Banking Regulation Act 1949 covers the basic concept of banking. The scope of banking is expanded in the present commercial scenario by this Act and also other connected legislations which are narrated in detail in the following lesson 2. Under Section 7 of the Banking Regulation Act 1949, every banking company must use as part of its name or in connection with its business any of the words bank, banker, banking, or banking company. No firm, individual, or group of individuals for the purpose of carrying on any business other than banking business use part of its or his name any of the words bank, banker, banking, or banking company. Section 6 of the Banking Regulation Act 1949 covers multifarious functions of banking business. The functions are not restricted to only acceptance of deposits, withdrawal of deposits, and granting of loans alone. Thus, the banking business is expanded to various activities suiting the present day modern requirement of banking institutions. So, the definition and meaning of banking must be understood in terms of the definition given under Section 5C and the various activities of banking narrated under Section 6 and the use and prohibition of certain terms and activities stated under Section 7, 8, 9 and Section 19 of the Banking Regulation Act 1949. These provisions are fully narrated in our lesson number 2. Let us now look at the legislative history of banking, its evolution and development. Let us also take up the evolution and development of banking law with special reference to UK. The law of banking was originated in the present form in England under law merchant as part of mercantile law, known as Lex Mercatoria in the 13th century. The law was based on the customs adopted and followed by the merchant community. These customs were recognized by the courts in England, and the decisions of the courts became authoritative judicial precedents. The usage of the negotiable instruments like the bills of exchange, promissory notes, and the checks became an integral part of the banking system, which acquired legal sanctity in the later years. The evolution of the present banking system in the world started with the Bank of England in 1694. Prior to this development, during the Middle Ages, the money lending activities were taken in the lead by the Jews. The Christian community was forbidden to carry lending business by the canon law at that time. But the other communities carried the banking business in the medieval era, and the popular banks were the Bank of Venice and the Bank of Barcelona. The countries which promoted the banking business from this period were Egypt, Greece, China, Italy, and England in the form of merchant banking. The modern Indian banking system had its roots in England. During 1600 in England, people treated the king and the royal family as an institution and deposited their money and bullion with the royal mint, which used to provide foreign exchange to the travelers and also exchange foreign coins. It was given to understand that in 1640, Charles I captured a huge bullion which was kept for safe custody in the royal mint, and then onwards, the merchants of England started keeping their money and valuables with the goldsmiths. These goldsmiths used to maintain strong rooms and issue receipts for the deposits, which were called goldsmiths' notes. The same is called today as a bank note. These goldsmiths also used to lend money for interest for long and short durations. They also used to finance the king. In the year 1672, Charles II had repudiated all the debts with the goldsmiths, and their business of banking came to a halt. Later on, they started a new system of maintaining current account with the depositors, and the system of current account was the genesis for the modern banking system. Prior to bringing in formal legislations, in England, banking law was basically a judge-made law. Lord Mansfield laid the foundation of English banking and commercial laws based on the law merchant. The later codified law was based on the judgments of Lord Mansfield and other judges. The modern banking law was evolved on the lines of establishing the Bank of England in 1694 through the Bank of England Act, which had multifarious systems of present-day banking. The bank had the power to issue notes. In the year 1844, Peel's Act was passed according monopoly to the Bank of England on note issue. Later on, the issue of banknotes in England was regulated by the Currency and Banknote Act 1920, which has given power to Bank of England to issue notes of £1 and 10 shillings. In 1947, the Bank of England was nationalized, and the power of appointing the governor of the bank and other high dignitaries was vested with the Crown. Presently in England, the banking system runs under the provisions of the Banking Act 1987, Banking Act 2009, Financial Services Banking Reform Act 2013, and other related legislations. Let us now look at the evolution and development of banking in India. In India, the system of banking was adopted both for commercial and non-commercial purposes. The references go back to the Vedic period. Money lending was in vogue, and money lenders also used to accept deposits. The money lenders were called as Seths or Shroffs. Mainly, the business of money lending was carried by the Vaisya community. The money lenders carried a highly profitable business, and Jain bankers were very famous along with the Vaisya community in India at that time. The French traveler Mr. J.V. Tavernier during 17th century has written that in India, in every village, there was a money changer by name Seths or Shroffs, who used to make remittance of money and issue letters of exchange. He wrote that foreign trade was financed in India at that time, and bills of exchange were drawn on Surat, payable in 2 months. In Buddhist period, in India also, bills of exchange were in use. The business of banking during this period was carried by Brahmanas and Kshatriyas, and they were known as Mahajans, Shreshtis, and Shahukars. Later on, during the Muslim era, banking was in vogue, and the bankers were also appointed as mint officers, money changers, and revenue officials to the government. Some of the bankers were called Jagat Sethas. The banking business suffered a setback during the Mughal period as rulers opposed charging of interest on loans, as it was taken as a sin under the Holy Quran. After the era of Mughals, India slowly came under the reins of East India Company, and later on under the British rule directly. Under the East India Company, the banking system again flourished, and the system was regulated subsequently by various British legislations for India. In India, during the year 1809, Bank of Bengal, also called the Presidency Bank, was established by a charter of Parliament. The East India Company was also a contributory to this bank. In 1840, the Bank of Bombay was established. Subsequently, the Bank of Madras was established, and these presidency banks were given the power of issuing notes, but the government withdrew this power in the year 1862. These presidency banks were amalgamated into the Imperial Bank of India in the year 1920 by the Imperial Bank of India Act 1920. The said Imperial Bank of India has become the present State Bank of India subsequently in the year 1955. The Imperial Bank of India did not have the power to issue banknotes. The bank was given the power to hold government balances and to manage the public debt and clearing houses till the formation of the Reserve Bank of India in the year 1935. The important and interesting feature of the bank was that the shareholders of the bank carry the same liability as that of the shareholders of any other bank which was registered under the Indian Companies Act, but the name of the bank did not contain the word limited. In India, the banking business is carried by both the government and private persons in both public and private sectors. The Reserve Bank of India is the central bank having the absolute control over the banks and the entire banking system in India. The Imperial Bank of India carried the functions of a commercial bank and also the central bank. The Royal Commission on Indian Currency and Finance in the year 1926 recommended for the establishment of the Reserve Bank of India as a central bank independent of the Imperial Bank of India. due to the constitutional reforms for India during 1930 and 31, a proposal was made for the transfer of responsibility at the center from British Indians, and it was also proposed that a reserve bank free from political influence must be established. The Indian Central Banking Inquiry Committee also recommended for the setting up of the Reserve Bank of India. Finally, a bill to establish the Reserve Bank of India was passed in the India Legislative Assembly on 22nd December 1933 and by the Council of States on 16th December 1934. The Reserve Bank was established on 1st April 1935 with multifarious functions. The Reserve Bank was vested with the power to regulate the issue of banknotes and the keeping of reserves with a view to secure monetary stability in India. It also operates the currency and credit system in India to its advantage. The bank was in partnership with private individuals. The bank was divided into 5 areas, namely Bombay, Calcutta, Madras, Delhi and Rangoon. After independence, the Reserve Bank was nationalized with effect from 1st January 1949 by the Reserve Bank Transfer to Public Ownership Act 1948, and the private individual shareholders of the Reserve Bank were paid compensation. After the establishment of the Reserve Bank of India and after independence, the Imperial Bank was nationalized to form State Bank of India under the State Bank of India Act 1955. Thus, the present State Bank of India is the former Imperial Bank of India. Apart from the above banks, during the 19th and 20th centuries in India, joint stock banks with limited liability were established and several banks were under European management. The prime banks happened to be the Punjab National Bank Limited, the Bank of India Limited, Canara Bank Limited, the Indian Bank Limited, Andhra Bank Limited, etc. Several banks were incorporated in the private sector with multifarious functions. The Government of India, following the concept of social control in the field of banking sector, in the year 1969, nationalized 14 leading banks, and in the year 1980, another 6 banks were nationalized. Thus, today we have banks in both public sector and also in private sector. We have another set of banks called foreign banks, where the banks were incorporated in foreign countries and their branches function in India after obtaining permission from the Reserve Bank of India. The Indian banks also have overseas branches in several countries. Let us now look at the difference between banks and financial institutions in India, as they have got different identities. The banking business includes financing also, but there are certain organizations which carry only finance operations, that is lending on interest, and they don't carry any banking functions. Such institutions are termed as NBFCs, that is non-banking financial companies. The Reserve Bank of India regulates both these banking and non-banking financial institutions. Apart from the Reserve Bank of India Act 1934, the Banking Regulation Act 1949 also regulates the working and functioning of banks in India. A banking company can carry finance business, but a purely finance company, that is a company carrying exclusively only finance business, cannot carry any banking business, as it is termed as NBFC. Now finally we will look at the form of banking institutions, that is how to carry the banking business. The banking business must be carried in the form of a company registered under the Companies Act 2013 or any previous company legislation, or as a registered cooperative society under the appropriate Cooperative Societies Act of either the central government or the state government. The banking institutions in India also can be incorporated by a statute like the State Bank of India Act 1955. Thus, the banking institutions can be incorporated either under a special statute or under the Companies Act or under the Cooperative Societies Act. In this lesson 1, We have discussed the evolution of banking business and the law thereon, and the historical perspective, the legislative history of the banking law in India, and then the very distinction between the banking and then financial institutions, and finally how to carry the banking institutions in what form. Various issues on the legislative support and then other aspects we will look at lesson 2. Thank you. Goodbye.